Well, welcome everybody. My name is Brian Runciman, Head of Content and Insight at BCS, the Chartered Institute for IT. This is our last HQ webinar of the year, and it's a follow-up to our previous Schrems II webinar. Obviously, this is somewhat of a movable feast in terms of the way things are changing. So I'd like to welcome you along to our conversation. We have three experts to speak to us, who I'll introduce shortly. Just to give some background, we've had a previous webinar on this subject where we looked at the importance of organizations mapping personal data flows, auditing access controls, those kinds of things. The idea of that particular webinar was just to raise awareness of the issues involved, that it's an integral part of a job now for an IT professional to understand the risks of data access by security agencies and the way that transfer of personal data outside the European Economic Area works at the moment, or will be working shortly. Since then, we've had quite a few changes. So we've had more guidance from the US Department of Commerce, rumors of a new privacy shield. We've had a specification from the European Data Protection Board on what additional safeguards means. We've had a draft set of standard contractual clauses, which came up across last time a lot, CCCs from the European Commission. Further European Court judgments which affect these discussions as well. And of course, looming on the horizon, will it be a no-deal Brexit, or will there be some sort of deal? Which is why, of course, later on, probably towards the end of January, we'll have another session because, as I say, this is a movable feast. So what I'd like to do is just introduce our three speakers. So I believe Chiara can't actually use her camera, so let me just introduce Chiara Rustici first. She's an independent academic and data regulation analyst. So welcome, Chiara. Hello to you. We've got Owen Sayers. So just like to introduce Owen. He's a senior partner at Seacon Solutions, an enterprise architect with a security focus, a lot of experience in the architecture area. He's got a lot to add here. So Owen, welcome. Thank you for attending today.
Cheers, Brian.
And we have also with us Adam Leon-Smith. Adam is Chief Technology Officer at Dragonfly and the chair of BCS SIGIST group. So welcome, Adam. Hello. Now,
thanks, Brian. Hi, everybody.
You might have seen in previous incarnations of the marketing material that we were due to have somebody just speaking to us, Joe Jones from the civil service side. Unfortunately, that hasn't panned out for various reasons, which you can probably guess behind the scenes. But maybe as things develop next month, we'll have one of those voices involved. So let's start off, shall we? We'll kick off this conversation. I'm going to come to Chiara first, actually. Considering where we are, what are the IT and business priorities now that a no-deal Brexit seems more than likely? So I'd like to hand over to you, Chiara, initially.
Thanks, Brian. Yes, I think that has upended a lot of our priorities, hasn't it? So I'll answer it from the perspective of all of our BCS members, so not just those based in the UK. And I want to make that quite clear. The UK is a key part of global value chains. So no deal Brexit will never just be a matter between the UK and the EU. It will be a matter for global trade. So understanding what part of a business value chain the UK plays is important for business in Canada, in Hong Kong, in Singapore, etc. So I know this is going to be counterintuitive, but while the first few webinars we kept saying priority for you is to map your data flows, now I'm going to be really contentious, say actually international data flows at this moment in time may well be low in your priorities. The IT sector's job right now is to understand what to prioritize and in a sense push back when all the vendors, all the consultants come and say, you've got to appoint a representative, you've got to do this, you've got to do standard contractual clauses. Remember that your key obligation is to minimize your data flows and only concern yourself with international data transfers if it's absolutely strictly necessary to your business goal, to your business proposition. So although it is not up to the IT department to decide the business priorities, the profession really has to almost handhold the business and has to understand the thought process to say, who are we actually going to trade with in this new no-deal Brexit situation? And only then, when it's clear to the business what the new landscape, the new trading landscape is, then start worrying about data flows. So in my head, there's about 10 things that you have to concern yourself with as a business in a no-deal Brexit scenario that directly impact the IT. And international data traffic, if you want, sits about a number 8. So let me quickly tell you what I think they are. Of course, we all have our own schedule and shopping list of to-dos, but mine goes something like that. First of all, map your markets, not your data flows, your markets. So you have to understand what your products, goods or services do in which markets, and understand what role the UK plays in that global map. So for example, not only what your markets as a UK business are, but whose market are you? You know, in whose value chain is your UK business a link of? So what part do you play in that value chain? You know, the big question in mapping your markets is, firstly, are you trading goods, services, or a mixture of both? Because they follow different rules, you have to ask the question, can I unbundle the service from the goods? You know, is it still profitable for me to do that? You have to ask yourself, what are the target markets? Which markets do I want to sell into? Which are my source markets? Which markets do I buy my raw materials from? You may be an intermediate market, you know, it's where the transformation happens, is where component parts are put together, yeah? You could be a transit market. Nothing happens, nothing is sourced in that market, nothing is sold in that market, nothing is transformed, it's just transiting, stockage, stored. You could be storing your goods there, or you could be doing some very basic transiting, and that is very important for data. So once you understand what kind of market, it really pays good dividends down the line to understand in a no-deal Brexit what function your business plays in these global value chains. I'll give you an example. A UK business could be a target market for another company. It could be EU, it could be outside the EU, but it's a market, a target market in its own right. Or there could be that Europeanizing stage in that other business strategy. You know, you push stuff through the UK because you source components or you source skills, professionals that make a semi-finished product or something that wouldn't normally comply with EU rules, something that then finally does. So that's important. If that's the function you've played until now in your business counterparties, then that's going to change, isn't it? You could be a warehousing, a distribution center. Okay, so let's move on. Once you've mapped that global chain, then you have to start communicating with your counterparties. And I make that a specific priority because although Brexit is very much front of mind in the UK, it is not the same in the rest of the world. And that's a good thing in many ways. The fact that Brexit hasn't dominated the press of Spanish or Italian or German or Belgian business publication means that in a way panic hasn't set in, and in a way you can still get there and control the narrative. So hit the phones and talk to your business counterparties. If the relationship is solid, you'll work stuff through. You know, if there's mutual advantage, you can share legal costs. But unless you talk, somebody else is going to control the narrative, and that could be a wrong kind of narrative. Don't forget, the priorities for everybody is to drop the hassle. Brexit is a hassle, and the temptation is to put it in the too difficult box, replace all UK businesses with local, or with other European economic area businesses. Your third priority is assess yours and theirs different tariff, custom, and VAT friction. Of course, you have to cost that into the cost base of your services. The business has to do that, because only if after everything is applied, it's still profitable to trade, then you continue to have a relationship. I think high on the priority is, once you've understood that trade with the EU is still viable and profitable, then you have to secure the EORI number, EORI numbers. Then you have to look at your .eu domain names. And then don't forget, you have to assess your counterparty's country of origin priorities. This matters because if your counterparties are planned to rely on preferential rates for products which are made up of at least 50–55% of EU components, and dealing with you outside of outside the European Union suddenly means that they no longer can avail themselves of those preferential rates, you have to talk to them. You have to understand if this country of origin percentage can be preserved somehow, but talk to your customers. Now, don't forget that if you or your business counterparties have only ever traded domestically or within the European Union, you will not be familiar with what happens when you trade internationally. So now, if you've decided that you still want to trade with European counterparties, suddenly you're trading internationally. So other stuff needs to happen. International classification system for products, and that's HS codes. So each of your product needs to have one. Do you know them? It will land on your desk as an IT manager at some point. So that's pretty high on your priorities. And then finally, I think only once you've decided that, you know, EU trade needs to continue, you can start worrying about data flows. That's when you really need to move data to the EU, and the EU, of course, back to you. And that's where the rubber hits the road. And we'll talk about that later. Of course, you have other priorities. Once you've decided that trade with Europe is important and mutually beneficial, viable, you have to look at what happens to that personal data, clients, customers, etc., that you had accumulated before the UK left the European Union. That's called legacy personal data. And to that legacy personal data, you have to continue to apply the EU GDPR, not the new UK data protection legal framework, but the old one as the law stood at the 31st of December this year. So legacy personal data, if you've decided that it really matters to you to hold on to those clients, those CVs, all that personal data of EU individuals, then you'll have to give it the EU GDPR treatment. So that's legacy personal data priority. And then if you really want to continue trading in the EU, you don't have a branch there, you don't have an establishment, but it matters to you to continue, you'll have to think about appointing a representative, a so-called GDPR representative. So as you can see, yes, data flows matter, but don't forget that you really only have to move what really matters to your business. And I think I'll leave it there, Brian.
Thank you very much, Clara. I appreciate that. We need to then move on to get some views from Owen. Before we do that, I meant to say at the introduction, but I'll say it now, having just had a look through the attendee list, where I saw a lot of names I recognised. Hello, everyone. If you have questions for the panel, they're happy to take them. We've got about 45 minutes for our session today. That's what we usually run to. So you know how Zoom works with the Q&A. Stick questions in there if you'd like to. If we can get around to them, we will do. Now, Owen, we were going to talk to you about the best way to keep personal data flowing when there's no new privacy shield in place as yet. So perhaps we can hand over to you.
Thanks, Brian. So we are probably all aware by now, painfully aware, that in the Schrems ruling, certain interpretations were made of transfers to countries that might not meet EU requirements. And during that, the CJEU identified that supplementary measures would have to be applied because standard contractual clauses on their own would not be enough. So in response to that, somewhat late response potentially, but in response to that, the European Data Protection Board have published 2 recommendation papers about a month ago now. And those were, the first one was documenting the supplementary measures and when you should apply them and how you should apply them. And the second was effectively a tool for those supplementary measures to enable you to assess how friendly or unfriendly a third country regime was to the EU expectations for what they call the European Essential Guarantees. Now, we're going to talk mainly about the first one, but the second one, as I say, is a tool that effectively comes into play when you are doing the analysis that's required under the first recommendation. So the recommendation for supplementary measures gives you a 6-step process, and you will find that some of these steps bleed over into what Chiara was already describing to you, and some of them will bleed over into the later analysis that Adam's going to give about the standard contractual clauses themselves. But essentially, these 6 steps are sufficient to identify whether you are transferring data internationally, the basis on which you're transferring it, whether the countries to which you are transferring it are countries that the EU will accept have regimes that are not unfriendly to GDPR. That's to say, regimes that the Schrems II complexities about supplementary measures do or do not apply. And then after that, it goes through how to apply those measures and some procedural steps that you may have to take. The measures themselves are split into 2 camps. There's the technical measures. There are 7 of those given in the use cases, and there are about 9 contractual and what they call contractual and organizational measures. Now, I won't go through the steps in any significant detail at this point, other than to say that step 1 is to know your transfers. Chiara's already identified the need to map your transfers. If you are already processing data under a GDPR regime, you should probably have a record of processing activities already under Article 30, and that will give you a lot of information relating to this. And if you have been transferring data to third countries, you probably already have created something to notify data subjects that you're doing so under the Article 13 and 14 requirements. You also have to consider when you're transferring data onward to another country. Now, some international service providers, some cloud providers are extremely good and extremely transparent at that. Others are somewhat less so, but it's your responsibility to confirm where your data is going and who is able to potentially access it, because you need that in order to apply the correct assessment of that third country legal regime. The important thing here is that the use cases lay down quite a lot of specific approaches that the EDPB think are either adequate or sufficient or are not. Even where you do not have to apply them, strictly speaking, have to apply them, they are useful for you to understand because they are at least highly suggestive of the way in which the courts and the supervising authorities will interpret the measures that you have taken under your general obligation as a controller to protect personal data. So the second step is that you identify the basis, the tool that you're going to use to send your data. Now, typically, if the country is an adequate country, there are 12, 11 and a half if you consider that Canada only has adequacy for commercial transfers. If it's one of those countries, then your examination of this recommendation effectively ends there, because there is no obligation on you to then follow through with supplementary measures. If the country is adequate, all is good, and you can send your data as you wish. Now, in addition to the 12 countries that the EU have identified, the ICO and the UK government have been very, very clear that they intend to deem all countries that are within the European Economic Area to also be adequate. So you have the 27 countries of the EU, and then you have the countries that are in EFTA, all of whom will, from the 1st of January, be adequate and will require you to take no specific additional measures in order to send data to them. But if the country that you're sending to does not have that adequacy, and the majority of countries do not, then you have to pick one of the appropriate tools, and those are typically the standard contractual clauses, the binding corporate rules, codes of conduct, certification mechanisms, and ad hoc contractual clauses. The goal here is to ensure that whatever mechanism you are going to use, that data has got an essential equivalent adequacy to the European expectations. That is the objective here. There's no need to go over that baseline adequacy. So you identify what good looks like and then you apply good. You don't go for excellent. No obligation on you to do so. So once you've picked your tool, you then have to assess if that tool is in fact an effective tool to send to the countries that you wish to send the data to. Now, as the CJAU have already done for the US, they identified that because of a number of pieces of US legislation, the main ones that they have cited relating to things like the Foreign Intelligence Surveillance Act, the FISA Section 702, under that, any cloud provider or electronic communication service provider has an obligation to provide data to the US government or a government agency in the US on demand. This was further augmented with the Cloud Act, which was brought in 2018. You have to effectively do the same analysis yourself, and that can be quite complex. Within recommendation 1, there is an annex which lays down certain tools and facilities that you can use to rely on that, but you should also consider looking for legal advice to confirm your own assessment if it hasn't been done for you independently. In all cases, you can also go to the supervising authority. In our case, within the UK, that will be the ICO, and ask them for guidance, and I'm sure that they'll be able to assist you in terms of the specific aspects of a third country legislation that could be problematic. Furthermore, the European Data Protection Board has identified that they believe there is an obligation on any data processor or any data importer to whom you're sending the data, that they must also disclose to you anything that they believe is relevant in their country. So you have multiple sources that you have to bring together effectively into a mini assessment for each of the individual countries. So having done that, you then have to make this assessment: is the country good enough to go with the tool that you've identified in Article 46, or do you then have to do supplementary measures? I should have, of course, have said that under an Article 49 derogation, there is the ability for you to send data on an intermittent, irregular basis for small quantities. That also would stop this analysis, because you don't have to do this depth of analysis for an irregular or infrequent transfer of data, but that's on a case-by-case basis. So when we get to step 4, applying the supplementary measures, here we have to look at the technical and the non-technical measures that can be applied. The Data Protection Board have come out and been clear that they do not believe that non-technical measures on their own are likely to be sufficient. So you're probably going to have to apply some form of technical measure, and the one that people are most familiar with is encryption. And they have generated 7 use cases, of which 3 are directly relating to encryption. 1 is peripherally related to encryption, and they give you really useful guidance as to when you can rely upon encryption and when you can't. And I know that Adam has got a specific example where he has been looking at that he'll cover later on. Having then applied the supplementary measures, and I'll discuss exactly what these technical ones are in a little bit more depth shortly. But having applied them, some of them then have procedural steps that you must take. If you have modified the standard contractual clauses, you're able to do that by adding supplementary clauses which do not affect the underlying SCCs. But if you have in any way modified them, you are obliged to go back to the ICO in our case and ask them what the implications of that are. Now, because we may rely on European SCCs in some cases, you would have to go to the supervising authority in the country of the data importer to ensure that they are willing to accept that. Or if you have established an EU representative, you could go to the supervising authority in that country and ask them, because they are effectively your footprint within the EU. And then when it comes to things like binding corporate rules, the ICO has already given really good guidance as to when you can rely upon them and the steps that you have to do in order to update those. So these are procedural steps, are the things that that need to be considered. The one area where the EDPB has not given any guidance in this respect is what they refer to as ad hoc measures. They have promised that they will give further guidance on how they seek to interpret those, but the reality is that ad hoc clauses, ad hoc contractual clauses, are so bespoke that it's unlikely that you're going to be able to get something from the European Data Protection Board, which will give you coverage on that. And as a result, I would always advise that you take appropriate legal guidance on the measures that you have, and have those assessed, and if necessary, go to the ICO or to the European, the relevant European supervising authority, and ask them to confirm that they believe that that's a safe position for you to take. Now, very quickly, I'll just I'll go through the. Oh, sorry. Step 6 is that you must review this from time to time. I'll very quickly go through the technical measures, because what the Data Protection Board have done is they have developed 7 use cases, and 5 of those we can take to be positive use cases, and 2 of those are negative use cases, in that they have put them up as an example to demonstrate circumstances where they believe that those technical measures do not give you the assurance that you think they may give you. Now, of the negative ones, one of those is simply where you have remote access from outside of the EEA by a provider who is looking at the data in the clear. I don't think very many people would seek to presume that there are technical controls that you can apply in that circumstance that would be effective. But the other one that they have looked at is really at the core of a lot of the encryption that we rely upon today. And that is encryption of data inside a foreign hosted service or a foreign operated service, where the data has to be processed in the clear. You will find people talking about data protection at rest and data protection in transit. But in a cloud service, for example, if you are consuming services within that cloud platform, that data currently, because encryption, homomorphic encryption, has not reached a level that we could use it in practice, that data has to be processed in the clear. And when that data is processed in the clear, it's the position of the EDPB that that data is not adequately protected. So the positive use cases that they have given for encryption are that if you take a piece of data, a blob of data, and you encrypt that data, and then you export that data to a data importer, but you keep the keys locally, and then you bring the data back whilst it's still encrypted, and then decrypt it locally, so effectively you use a cloud service for backup, that would be acceptable. It's not tremendously functional. But a number of people are already using that in technologies such as Dropbox and Box.com. You know, it's quite acceptable to use that, providing you apply an appropriate level of good commercial grade encryption and you apply it well. The other area where they've looked at encryption is in terms of the protection of data in transit. So the use case that they give is sending a piece of data from one country with adequacy, or one country which is deemed safe, to another country that is deemed safe, where it is passing through territories and environments where there is no adequacy. Now, this is the one area where the EDPB guidance goes somewhat further than the ICOs. The ICO has historically taken the view that data in transit does not need anything more than standard commercial protections. The EDPB have said that they believe that the encryption that you must apply here must not simply be at the transport layer, that it must also be the application layer. Now, that the way in which you interpret that is it's open to many interpretations. You could say that it requires to be something based on a PKI encryption, where both the sender and the receiver have their own encryption keys. It could be that some of the technologies that we have available to us today kind of bridge those two gaps, and you might deem that to be acceptable. The bottom line is you have to look at your encryption, determine whether the countries over which it could pass have the capability to break that encryption, and if in your informed opinion you think they could, add more encryption. That's what that use case essentially is saying. Now, I don't think we should need to run out and worry about replacing TLS tomorrow. But if you're sending data which is particularly sensitive, data which you have particular concerns about, then you may wish to augment that encryption by doing something else as well in the application tier. That leads us on to one of the other use cases, which is a protected recipient. This is where you're sending data to someone in a third country who is legally protected. Typically, for example, a legal advisor or a medical advisor. They are protected under the law in the third country from having to disclose the data, providing you encrypted data from you to them. That is perfectly okay. And then the final two use cases that they give that are successful are pseudonymization. A number of people are looking at pseudonymization very positively. If it's done well, that is a control that the European Data Protection Board will accept. There are certain criteria and characteristics about it. The main one to check there is that you have to do an analysis to ensure that there isn't other information in the public domain or other information available to a foreign government that could be used to reconstitute and re-identify the data subject that you've pseudonymized. And then the final one that they give is potentially something of an edge case. I'm sure there are people that are doing it, although it's not within my own personal experience, and that is called split and multi-party processing, where you take the data, you divide it into two or more groups. You then send each of those pieces of data to different data processors or different data importers. They do what they have to do with it, and then they send it back to you and you reconstitute it. That is, I suspect that there will be more and more cases where that comes up. It does, as you might imagine, cross over on the point that Chiara's already made about minimizing your data transfers. And here you obviously would only send the minimal amount of data that is required to each of those processors. Those are the technical measures. The non-technical measures are really principally associated with things that you were already defined in the SCCs and things that you were already defined within the obligations that you have. The difficulty that we have as business users of services that are provided from overseas, in particular with cloud services, is that the terms of service that they apply do not really give you the flexibility or the latitude to add these into those terms of service. What I suspect we will see, and Microsoft have already started a little bit on that journey, is a modification of their terms to make them slightly more friendly. It is within their power to, for example, give you more transparency as to how they are processing the data. They already do give a lot of information about that, but they can give you a lot more. There are means by which they can commit to audits. There are additional controls that they can put in place contractually. The only caveat that I have about a contractual control is that the reality is, in a third country, their domestic law may trump any contract that you have. And that is why the Data Protection Board have identified that you almost certainly also have to apply technical measures as well for those circumstances where the domestic law might override it. So it's It's complex but not complicated. They've laid down some really good use cases. Any business can go and look at that and navigate a pathway through that is a sufficiently well-balanced piece of risk management. And I suspect that's one of the things that Adam will walk us through shortly. But the reality is that we have much more clarity now. It may not in some respects be the clarity that we wanted. It may not in some respects simply allow us to continue with a business as usual approach. But there's nothing here that should be beyond the wit of your IT departments or your service providers. Brian, I think that's all I would say on that just now, and I'll come back to encryption or any questions that people may raise. But essentially, that is the gallop through the two recommendations.
Lovely, thank you, Owen. Well, actually, we've already had a few questions come in, and as they were coming in, Chiara answered them. So that's the kind of efficiency we like.
Well done, Chiara. I like that.
Owen. So we'll no doubt to carry on that conversation again shortly. Let's go over to Adam. He's going to speak to us about standard contractual clauses because of the new standard published by the EU Commission, and you've got some interesting stuff, Adam. So over to you.
That's right. So this is actually my fourth webinar on international data flows with both the British Computer Society and the Open Security Summit since the Schrems II decision. And in the first three, I've been focused on some of the topics that Owen was talking about there. In particular, the use of an email provider, which is provided by a US cloud company, and also my file stores, which are in a infrastructure as a service, another US cloud provider. I have a server that has encrypted data storage using a key management store, and trying to determine if either of those could be compliant based on the European views relating to supplementary measures, and also the constraints in all of the various pieces of guidance that have come out over the last few months. And the resounding answer has been no. But as Owen also alluded to, there is a difference between the European view and the ICO view on some of this. So now with 14 days to go until Brexit, unfortunately, it is time for action. So I pulled out the new standard contractual clauses recommended by the European Data Protection Board. And I went through them in some detail. And most of it is relatively straightforward based on existing good data protection practice, existing technical and organizational measures. But there were a few things that were quite interesting and have caused me to take action around technical measures. The first thing that I noted was that all my data subjects can see a copy of these clauses. So to talk more about the specific use case I have a UK company and I have a Spanish subsidiary, and I have Spanish employees in the Spanish subsidiary whose payroll data, employee records, and identification data needs to be processed by my HR team in the UK. Now, in order for that data transfer to continue, I have no option but to go through the process Owen was outlining. So step one, I need to get these SCCs in place, and I need to make sure that I can provide them to all my Spanish employees on request. The next thing I came across was strictly necessary access. So I need to have in place controls so only people who are really necessary to operate the processes, in this case HR processes, can access this data. That means, for example, having an IT administrator that could override the authorization and give someone else access in the UK might be a problem. Those are relatively straightforward so far, but it gets more difficult. So I have to warrant that I have no reason to believe that the laws in the UK may require inappropriate disclosure of the data based on the fundamental rights and freedoms proportionate to a democratic society in the view of Europe. And I have to document that legal assessment and analysis as part of my compliance with this standard contractual clause. And I'll come back to later how I did that legal assessment. But it is quite an onerous process for a lay business or a lay business person to do. The next obligation within the SCCs that really caught my eye was around providing the greatest possible amount of relevant information on the requests received from any authorities. So I have to establish a reporting process from the UK to my EU company for any requests from authorities, and I have to commit my UK company to fighting any such release of data through legal means. And then the real problem that I got to was with any sub-processors, I have to write in third-party beneficiary rights to data subjects, and I have to make my Spanish company a beneficiary to the sub-processor contracts in the event of bankruptcy of my UK company. So I'm not going to be able to get those clauses inserted in the big tech cloud providers' contracts by the end of the year. So that led me on to, well, I have to remove the sub-processors, and I have to look at the supplementary measures that were outlined by Owen before. And then the final thing about the SCCs really is I have to commit to regulation under European law by APDCAT, the Data Protection Authority in the region that my Spanish subsidiary is established. So the biggest thing there is really I have to take some organizational steps around segregation and around reporting, and I have to take some technical measures in order to remove the sub-processors. So going back to the use case, which is I have a small amount of data relating to employment record and employees that has to be passed to UK HR representatives, I made a number of immediate technical decisions. Firstly, secondary encryption. When data is emailed between people, it must be encrypted using a password which is not passed via email. Relatively easy to do with off-the-shelf or open source encryption software. And given the small amount of data it applies to and the small amount of data subjects that I have here, it is relatively doable, although inconvenient for staff. The second thing I've put in place is I've removed all IT administrator access to the area where the data is stored. So the authorization of any staff that can access the data is done by the IT staff in Spain. So there is no risk of a UK officer of the company or a UK employee being able to change who has access to the data, which is limited to just 2 people now. The next thing I did was I have implemented client-side encryption. So the 2 people who have access to the data run a local piece of software. When they access their network drive and go into this particular folder, they can only access the data by firing up a piece of software on their local machine and typing in a strong password. That means that as well as having authentication and authorization controlled at the file storage level, I have another level of encryption that means the cloud provider, if the cloud provider, following a US court order, goes and gets the key out of the key management system and decrypts the disk that the data is stored in and bypasses the Windows authentication and authorization steps, they still won't be able to access the data because it's AES 256 encrypted. The last technical measure I put in place was I created a Warrant Canary Slack channel. Every month, an automated message goes out to anyone that I add to the channel, or anyone that has access to this data, asking them to assert that they have not been asked to provide the data to any authorities or other people in the UK. If they do not respond on that channel, I need to consider that a data breach. So those were the technical measures. And I think the last piece is really the legal assessment. So how do I justify to myself that the UK law is appropriate based on the European requirements? So a few things to note that really aided me here is, first of all, because of the technical measures that I've put in place, no onward transfers of the data are going to be possible from the UK, apart from the risk of fraud, which I can't prevent through legal measures anyway. As I control the technical infrastructure from the controller side, from the data exporter side, it's much less relevant, the ICO's ability to enforce people's rights. We have the local EU regulator has responsibility under the SCC and the ability to grant redress. I have liability that is directly applicable to staff if that data is lost, and I've removed a lot of the UK control. So I didn't consider some of the arguments that the ICO isn't necessarily as good at enforcing things as the EU would like. I also considered the immigration derogation. A lot of people say that the UK can't gain adequacy because of the immigration issues. The nature of the data that I'm processing isn't relevant to UK immigration, so I've discounted that from my analysis. I've also based my analysis based on the current legislation. So if the UK diverges at all from its current legislation, I have to revisit this analysis regularly. So those were some of the things I considered around the scoping of my legal analysis. And I also looked at the DCMS's data on how to make these adequacy decisions. And that's essentially what I'm doing. I'm making an adequacy decision as a business instead of as a court or a nation state. So in all the guidance that I've seen, I'm required to make an objective assessment that people's rights and freedoms might be compromised. That means I can only take into account data that is available in the public domain or I have experienced. I'm not going to make vast sweeping assumptions about what GCHQ might be able to do. I'm going to look at the Intelligence and Security Council reports. I'm going to look at things like the Regulation of Investigatory Powers Act. My conclusion on doing this legal analysis was that the data is so limited. It is data that is likely to be accessible by authorities regardless, particularly in terms of things like passports. And it would only be accessed by UK authorities in the event of a criminal or a national security investigation. And therefore, the view I take is that the necessity and the proportionality of that is reasonable for me to continue to do the processing. The only real risk I have is that that individual UK employee is ordered by a court or a police officer in order to, or an intelligence operative, to hand over that data. And for that, I have the warrant canary that will help me to manage that risk. Now, I may not be right about all of this, and I'll take legal advice, but with 14 days to go before I'm in non-compliance, these are the measures that have got me into a place where I think the risk has been minimized to a reasonable degree.
Thank you very much, Adam. I mean, as practical examples go, I think that was very, very informative. So we appreciate that input. Thanks. So again, we've had a couple of other questions which Kiara and Owen have been answering as we go along. So we very much appreciate that. Keep those coming in, folks. We're past our 45 minutes, but there's one other aspect we just wanted to cover. If Owen's happy to do this, we're talking about end-to-end encryption, the feasibility of that in day-to-day business practice. Owen, is that something you'd like to pick up for us?
Yeah, by all means, Brian. So this question, when we were discussing it, came up because there is a split personality emerging within the EU today, where the European Data Protection Board, as a result of Schrems, are identifying that encryption must be effective with no backdoors, with no interception points, with no interruptions. Whereas a number of EU and international law enforcement and security service type sources are expressing their concern that end-to-end encryption should have legitimate means of access for law enforcement purposes, effectively as to colloquially refer to it as a backdoor, a master key that enables them to gain access. Now, you certainly can apply an end-to-end encryption. People have been doing it for many years. If you use a PKI, you are effectively applying an end-to-end point-to-point, person-to-person encryption. And one of the use cases that the ADPB have given us is expressly that. If you are, for example, communicating with a legal representative in the US, that legal representative can operate under legal privilege in the US and is protected from having to give the data to any US authorities. And you can create an encrypted transfer from you to them, end to end, no interruptions, and all is good. The reality, however, is that an awful lot of end-to-end encryption to service providers is not necessarily or quite as end-to-end as you would anticipate. And this is what the CGAU identified when they were examining the interception capabilities of on transatlantic cables for the internet. So you can apply end-to-end encryption. You should apply it wherever it's appropriate and possible for you to do so, but you should also keep a watching brief on the fact that the end-to-end encryption that we would like to rely upon is under constant, regular challenge from a number of organisations whom you may well be happy to believe have legitimate need in the interests of public safety to access your data. Does that cover that, Brian, or is there anything else that I need to go into there?
No, I think it does. Thank you. Now we're at the 15-minute mark. As we say, we usually do 45 here, but I obviously it's an important subject. Is there anything that Owen, Adam, or Chiara would like to add in, or shall we pick this up again, because we're going to do another event at the end of January, and some of the material here will be republished. Just ask Chiara, do you have anything you'd like to add at this point?
I think I would like to take instructions from our audience, which, you know, 1 week to Christmas, sitting here for the umpteenth Schrems webinar is obviously very, very participative. So I'd like to know if you can write in the chat, what exactly is the burning question, you know, both in the run-up to the 31st of December and also immediately after, because whether there's a deal or not, there will be disruption, because not everything will be ratified in time. There will be a period of uncertainty. So what would you prioritize, and what would you like the BCS to address? That's my line, Brian.
Thank you, Chiara. So if anyone has any thoughts on that in the next few minutes, please stick them in the Q&A. Adam, any other thoughts from yourself you think should be discussed at this point?
No, just to highlight, I think the you know, when you're putting in place these standard contractual clauses and you're starting to deal with EU data, the #1 thing you need to do is look at removing sub-processes through the use of supplementary measures. So what I explained was the steps that I've taken around extra levels of encryption mean that I no longer need to consider these cloud providers as sub-processes, which greatly simplifies the operations. So technical controls can be put in place in some use cases that help mitigate a lot of the legal problems.
Thanks, Adam. We have had a comment just come in, a couple of comments coming from the chat here, actually, Chiara. Biggest issue is having to rush to put in standard contractual clauses as it stands, and then having to redo within 12 months of the news going live. Is that something we can pick up perhaps next month? Chiara, any views on that one?
I've just got one comment. It would be useful if the EU could provide them in Word document format rather than PDF, because I spent a lot of time copying and pasting.
Absolutely. I think we can promise, almost guarantee, that in January we'll have a lot more people willing to go on the record, and a lot more lawyers who are naturally cautious and don't want to speak until everything has fallen into place. We'll have a good legal team addressing these issues in January. So yes.
Okay. Someone reckons they were available in Word. Adam?
Yes, they were, but the new ones, unfortunately, are not.
Okay.
To my surprise.
There we go. We won't start a fight on that. An exchange of views, thank you. So we have a suggestion from anonymous attendee that next time we could cover what we need to do to ensure compliance with UK GDPR and exporting data. Short answers now, or shall we leave that for later on? Chiara?
No, I think that's for later. That there is going to be fun and games with two parallel regimes that you have to apply: the EU GDPR, frozen in time for legacy data or for EU individuals, and the UK GDPR. So yes, I think we're going to deep dive in January into that.
Okay, well, I'll add that one into our document for setting up the discussion next time. I think we'd like to thank all our participants. We're nearly at the hour mark now. So what will happen here is that this webinar has been recorded. We'll do an edited version of it for release in early January.